Assalamualaikum warahmatullahi taala wabarakatuh. So today our group would like to present regarding the patent for Foldy bike. Our group member consist of 5 members including me. And next, I will start first for the introduction of patent. So regarding to the website on my IPO, definition of patent is an exclusive right granted for an invention, which is a product or an process that provide a new way of doing something or offer a new technical solution to a problem. Based on our interview session with Mr. Vincent, he explained that technology and software company often have patent for their design. For example, Steve Jobs and his 3 other members that filed a patent for the personal computer of Apple. Next, the utility innovation. The definition of utility innovation is the exclusive right that granted for minor invention, which means that any improvement of an existing process or product can be registered for utility innovation. And there is also a differentiation between patent and the utility innovation, which means that the utility innovation does not require to satisfy the test of inventiveness as required of a patent. So that's all from me. I'll pass to the next person.
Assalamualaikum warahmatullahi wabarakatuh. My name is Lisa Afika binti Muhammad Yaakob, 1182139. Okay. I would like to introduce our innovation that we want to be patent, which is this Foldy bike. This Foldy bike is referring to the this generation right now. So we hope that this Foldy bike will make it more interesting for the younger generation and also will be more helpful for the older generation. So I would like to elaborate more on how this Foldy bike will be functioning. So the first one, we certainly say that this Foldy bike will be suited for traveling since it is more lighter as we are using aluminium alloy rather than using steel. And this one also is an automatic folding, which as you can see at the bottom of the Foldy bike, the illustration below, this one is a stabilizer that is you can just press the button and then it can be automatically folding. And furthermore, this Foldy bike also we do have bicycle tracker device, which is you can link into your device, whichever device that you are using. So you can track the bicycle, which is it the bicycle has been locked, or even also this Foldy bike we do have GPS tracker at the below of the seat. So then if the Foldy bike is moving, so like they can pop up your notification and you can see like, okay, is it correct? If you are in curiosity, so then you can just turn on the alarm. So you can just run onto your Foldy bike after you are turning on the alarm. So it is also can reduce the stealing risk, as this Foldy bike can turn the alarm for you before you go run to the Foldy bike. And the last one, this Foldy bike also we do have bicycle lamp control and recorder, which is you can just control the lamp without pressing it. You can just as we have the recorder, so you just record your voice, which is you want to make it the brightness lower or higher. Okay, but this Foldy bike we have interviewed Mr. Vincent, and he said that he recommended us to patent our own product even during COVID-19, which is when we want to patent it, it maybe have higher costly, but then somehow as we know high cost maybe will have high security. And before we invented this idea, we have been researched for like in numerous places such as at the World Intellectual Property Innovation Organization, which is WIPO, IP Australia, and many more. And we hope that during this COVID-19 or even after COVID, since we know that many people are channeling into healthy lifestyle, so we hope that this Foldy bike will have like more market and can sustain our economy after this. So I think that's all from me. Thank you.
My name is Muhammad Shati, BM Muslim, matric number 18128. So what is the of patent? Based on the Patent Act on subsection 32, register of patent. The register shall keep and maintain the register called the register of patent. The register of patent shall contain all such matter and particular relating to the patent as may be prescribed. The register of patent shall be kept in such form and on such medium as may be prescribed. In next slide. So the patentability requirement, the eligibility criteria for patentable invention. First, is a new or novel. This means that the invention has not been publicly disclosed in any form anywhere in the world. The next, involved an inventive step. This means that the invention must not be of use to someone with knowledge and experience in the technological field of invention. Is industrial is applicable. This means that the invention is capable of being made or used in any industry. And the last one does not fall within the scope of non-patentable invention as stipulated by Malaysian patent law. Okay, non-patentable invention. So first, discover scientific theory and mathematical method. To plant or animal variety or essential biological process for the production of plants or animal, not including man-made living microorganism, microbiological process and product. Third, scheme, rules or method for doing business, performing a purely mental edge or playing games. And the last, a method for the treatment of human or animal body by surgery or therapy. And diagnosis, a method practiced on the human or animal body. In addition to the above, Malaysian patent law also prohibit the patenting of any invention that would be contrary to public order or morality. Okay, the next slide. Based on interview with Mr. Vincent Lijau, the APO Malaysia has incentives during pandemic COVID-19, which there is no need to change patent license during first 6 months of COVID-19. It will be a great incentive to Malaysian society during pandemic. Next, the main responsibility of patent agent is to assist the client in obtaining legal protection for his or her innovation by submitting the patent application and seeing that the application is prosecuted all the way to registration. Okay, based on the interview question, which is what law action should be taken if the company or organization with or without intention to use other product patent. Mr. Vincent Lijau said Malaysian patent law does not allow for administrative enforcement measure. The patent owner right may only be enforced once the patent has been granted and via civil action. Okay. In the case of patent infringement, no criminal charge may be brought against the infringer if you're not registered the patent. Okay, that's all from me. Thank you.
All right, my name is Nur Ali Adira binti Zakaria, matric number 1182871. So this slide show application procedure in Malaysia to apply the patent. The owner of the invention is eligible to apply for a patent. The owner may be an individual or a company. In Malaysia, a patent application must be filled with the ISMA APO, the Patent Registration Office Overseas Administrations, patent processing and registration, as well as utility certificates. So there is a flow chart or step of patent registration procedure in Malaysia. So the first one is filing application. After receiving the application and the prescribed payment of the official application fee, the former examiner of the patent register will review the application to ensure that the minimum application requirements have been fulfilled. Second, application accorded filing dates. Third, preliminary examination, which is the following applications are subject to preliminary review, whereby application are reviewed for compliance with formal requirements. Fourth, application laid open for public inspection. After 18 months from the filing date or the earliest priority date, details of the pending Malaysian application, including the patent specification, are made available for public inspection. However, the application is not released in printed form. Fifth, a request for substantive examination. Substantive examination, either full examination or modified examination, or the request to defer the request for substantive examination, which must be made within 2 years from the filing date of the application. If not within the stipulated period, the application will be considered withdrawn. The last one is registration certificate of grant. After payment of the registration fee, a grant certificate will be issued, and items of detailed information will be registered in the patent registry. In addition, the details of the patent along with the abstract will be published in government gaze. Next presenter.
I will explain regarding the issue that are related to the patent, which is that I will explain about the local case on the Kintai International Limited versus Petrofed E&C Sdn Bhd. In this case, the plaintiff is the Kintai, while the defendant is the Petrofed. This case is started when the patent 895,004 was being registered and owned by the Kintai International, which is installed for the purpose of offshore oil production. Griffon Energy was granted a license for both patent by Kintai, which means that Griffon is a patent licensee for both patent, and it started when Griffon filed suit in the High Court against Petrofed for patent infringement of Claim 1 and 13 of Patent 5004 and Claim 1 of Patent 898. Next, the issue that arises in this case is that first, whether the written opinion of the International Searching Authority (ISA) should be considered by the courts in deciding the novelty and the inventiveness of the patent claim. As a result, the High Court held that they may consider ISA written opinion, but are not taking into account by such opinion which are not conclusive. And the second issue is that whether Petrofed was liable for patent infringement because the alleged infringement occurred before the grant of both patents. In this case, the judge held that Section 35, Subsection 1 of the Patent Act, which state that the duration of a patent is 20 years from the filing date of the application, is only applied to Subsection 1B and 1C. However, the Subsection 1B and C did not apply in this case. Therefore, based on those sections, the duration of the two patent prove that it shall take effect from the filing date of the two patent application. And although Petrofed has alleged infringement occurred before the patent were granted, it happened after the filing date for both patent and during the duration of the patent. For the decision of the court, the court held that it proved that Petrofed have infringed both Claim 1 and 13 of Patent 5004 and Claim 1 of Patent 898. So it proved that Petrofed has infringed both patents in this case.
My name is Nur Zahida binti Rizwan, match rate number 1182126. During the interview with Mr. Vincent Lejau, we discussed a little bit about international cases about Apple and Samsung, where Apple claimed infringement of the look and feel of the iPhones and iPad in Samsung's Galaxy S line, and Samsung responded with a countersuit for infringement of wireless networking technology patents. During 2011, patent first sued Samsung in the Northern District of California, and the Samsung is countersued, which awarding about $1.049 billion in damages for Samsung's infringement. However, the jury also found that Apple also infringed Samsung patents, awarding about $158,400 million, and Samsung appealed to the federal court. And then a panel decided that there was no infringement because the patent on site to unlock features were invalid based on the prior art. An en banc hearing reversed the three-judge panel decisions and restored the $120 million award in 2016. And in conclusion, the trials between Apple and Samsung have resulted that Apple being awarded and the settlement was over $500 million. Next slide. Conclusions and recommendations. Patent and utility innovation must be one in the world where it is recognized internationally. And the invention of this Foldy bike will surely benefit many people, such as travelers, sport athletes, and people who love a healthy lifestyle. Besides that, the registration for patent is easy and the cost is affordable, especially for the business, where it can be done either manually or via online. And my IPO have a library that collects all the intellectual property in Malaysia, all the data about the intellectual property, which are located at the My IPO office at Kuala Lumpur, in which any people can access to the library if they want to know more about the patent issues or make it as a reference point for the researchers. And also it is suitable for the inventor to find out any new technology that have been patented to avoid any infringement cases that will happen in the future. And it is really, really recommended for the people to have an awareness about the importance of intellectual property, where some of them did not realize that their intellectual property is being exposed to the risk of plagiarized and even registered as someone else's intellectual property. That's all from us. Thank you.